and two more just in time. Any bill introductions today? No. Well, we will do it again at our Monday meeting, have that available. And today, we have one item. We have a hearing on House Bill 2489. We had a fiscal note made available, and I think it was 0. And so nothing startling to report there. But David, could you start us out with a briefing on 2489 as it is right now?
Thank you, Mr. Chairman. Good morning. House Bill 2489 was a bill requested by the Office of the State Bank Commissioner as part of the agency's required report and recommended legislation that they were to do under KSA 9-2325 as part of the Technology-Enabled Fiduciary Financial Institutions Act, or the TEFI Act. What 2489 does, it does provide several amendments throughout the TEFI Act. Some are technical in nature to correct subsection references, grammatical errors, and provide consistent terminology throughout the Act. But there are also some other provisions of the bill that would add a new section to the TEFI Act, establishing procedures for when a TEFI is undercapitalized or insolvent. If undercapitalized, the bank commissioner may enter into an informal memorandum notifying the TEFI of the unsatisfactory condition and require correction within a specified period of time. Or the commissioner may take charge of the TEFI and its property and assets. The commissioner would appoint a special deputy commissioner to take charge of the affairs temporarily of the TEFI. In the case of a TEFI being insolvent, the commissioner may take charge of the TEFI in the same manner as previously stated, or assign any or all of the TEFI's accounts, associated property and associated assets to successor trustees. And then just lays out those designated successor trustees may be required when a TEFI is undercapitalized, appears insolvent, or intends to voluntarily cease engaging in business or appear to the bank commissioner to so intend to cease business. The bill also then amends the definition of FIDFIN and strikes references to loans, extensions of credit, and direct investments, and adds language saying it would be the acquisition of alternative assets on behalf of and through a FIDFIN trust. It's on Section 2, page 3 of the bill. The bill also adds additional criteria for when the banking board may deny a TEFI charter application. It adds 3 new criteria to the existing statute. There'd be if the public need for the proposed TEFI and whether the existing TEFIs are meeting such need, the prospects for success of the proposed TEFI, or any other criteria the board may require. The bill also amends language regarding the $500,000 TEFI initial fee, application fee. The application would be a non-refundable fee of $500,000 to be remitted in a manner prescribed by the commissioner. It also amends language regarding the sending of TEFI assessment statements from the commissioner. The date would be changed from December 1 to July 1. And the payment of those assessments would be made within 15 business days after the date the statement was sent by the commissioner. The commissioner may allow installment periods for payment, but not more frequently than monthly. The bill also adds a definition of insolvent. Just pick up the definition that is currently in the state banking code for banks and trust companies and apply that to TEFIs. And adds language giving the commissioner discretion to require a TEFI to maintain bonds and insurance policies regarding the operations in amounts deemed appropriate by the commissioner, and give the banking board discretion to require a TEFI to have excess capital based on the character and qualifications of a TEFI board of directors and the nature of the business. It amends language relating to the examination of TEFIs. The commissioner would not evaluate the safety and soundness of a TEFI, but would instead evaluate the profitability of a TEFI, evaluate the TEFI's compliance with applicable state and federal laws, and evaluate the TEFI's IT systems, policies, and practices. The banking board and the commissioner may examine any aspect of a TEFI to aid in the understanding of the TEFI's business operations, financial status, and effects on the state, or to help guide the adoption of rules and regulations or proposals for any legislative changes. The bill also amends the powers of a TEFI to engage in trust business by requiring such trust business be incidental to engaging in FIDFIN transactions and to the receiving, retaining, and managing of alternative asset custody accounts. It adds language to state when a TEFI may extend financing through loans or direct investments and clarify that a TEFI customer is not a party to the financing, but is only involved in the FIDFIN transaction through the sale of one or more of the customer's alternative assets to the FIDFIN trust. Requires the commissioner to adopt rules and regulations that enumerate categories of FIDFIN transactions. The rules and regulations would specify concentration limits for each category based on the category's risk profile. A TEFI would not engage in any FIDFIN transactions that would result in an asset concentration greater than the limit for that particular category. Bill also requires a TEFI to disclose to a customer the information required by rules and regulations of the commissioner to ensure that the customer is informed regarding the nature of the transaction with the TEFI. Requires a TEFI to provide prompt written notice to the commissioner when engaging a party to provide services or when the TEFI is employed as a trust advisor. Then also that a TEFI by contract or otherwise causes any service authorized by the TEFI Act or the State Banking Code to be performed for such TEFI or on behalf of the TEFI, the performance would be subject to the same regulation and examination by the bank commissioner to the same extent as if the TEFI itself was providing that service and not contracting it out. And then also, the bill also adds language concerning procedures to end the pilot program under the TEFI Act and convert beneficent's conditional charter to a full charter. After the commissioner completes a regulatory exam of beneficent fiduciary financial institution, beneficent may submit an application to the State Banking Board, which would be consider an application to convert that conditional charter to a full charter. If the application is approved, the pilot program would immediately end, and then the board may start approving other charter applications from other potential TEFIs. If the application is not granted, beneficent is given time to address deficiencies and resubmit, and they would not be charged an additional application fee. If the conditional charter is not converted before 6 months have passed after a second regulatory examination and no conversion application is pending, the bank commissioner would revoke the beneficent charter, the pilot program would end, and the State Banking Board would not approve any new TEFI charters. And then finally, there's the bill amends KSA 39-1401 to add fiduciary financial institution to the definition of financial institution within that statute, making a fiduciary financial institution a mandatory reporter of elder abuse. This just adds it to the list of the current ones. You have banks, trust companies, escrow companies, finance companies, savings institutions, or credit unions. All currently are sort of mandatory reporters, and this would just add fiduciary financial institution to that list as well. I know there's a lot going on there, Mr. Chairman, but I'm happy to stay in for any questions.
That was a lot going on, David. Any questions for David? The only, I guess it's not a question, but what would be an automatic difference was right above the mandatory reporter. There's another bill that makes that particular piece not necessary, right, on the date?
On the date there is, I believe, there is, this committee introduced a bill saying as of December 31st, 2021, the conditional charter is converted to a full charter, and there's also a bill in the Senate that was on general orders yesterday, Senate Bill 337, that also just makes that date change and makes that clear that it was December 31st, 2021, but it's still kind of working through the process.
Okay. Any other questions for David? You had a lot to wade through. Thanks, David, very much. Okay, we will open the hearing on House Bill 2489, and our first testimony will be proponent testimony, and we have the Office of the State Bank Commissioner. And Matt, I hope I pronounce your last name right, Shoger? Okay, good. Matt will be testifying on behalf of the Office of the State Bank Commissioner, and welcome to the committee, Matt.
I was involved in drafting many of the changes proposed in this bill, and I will provide an overview of those changes in this hearing today. Last session, the legislature passed Senate substitute for House Bill 2074, which created technology-enabled fiduciary sections of that law. Both charge the OSBC with the duty of recommending any legislation necessary to implement the provisions of the TEFI Act. We've learned a lot at the OSBC about TEFIs over the last year. We've been reviewing and administering the Act since its effective date of July 1st. As we've learned more and thought through how this Act applies,
Matt, Bart, could you get to where either raise the mic or a little closer to it, understand some of the sounds not we need a taller podium.
oh, okay. Okay, should I just keep going from where I was? Okay, that's all right. Since then, Ben and the OSBC have discussed the bill further, and we've come to a lot more agreement on what should be in this bill. Several of our points of agreement would involve amendments to the bill, and we're working on some of the exact language for that, and we hope to get that to you soon. Ben and the OSBC reached agreement on some provisions which clarify issues unique to TEFIs, specifically what the OSBC will evaluate during an examination, that a FIDFIN transaction is often a sale from the perspective of the customer, that certain required notifications to the OSBC must be in writing and must be made in a certain time frame, when the first yearly assessment will be due, and narrowing the fingerprinting requirement to just officers, directors, and organizers of a TEFI to resolve an issue that currently prevents the OSBC from obtaining FBI background checks. We also agreed to some changes that harmonize TEFI provisions with existing approaches for banks and trust companies, specifically to what extent a TEFI can engage in traditional trust business, that the OSBC can examine a TEFI's service providers, that initial fees are received at the time of application, that assessments are allocated and paid in July, how both fees and assessments will be paid, that the OSBC can require disclosures to customers, and the TEFIs are mandatory reporters for purposes of elder abuse. We also agreed to several proposed technical corrections and wording improvements. For some of the remaining items where we do not yet agree, we've agreed that it might be better to wait until after an examination to review those items. Those items all involve the financial intricacies of a TEFI, or at least the intricacies of an exam. Specifically, these items are capital, insurance, and bonding requirements, limitations on concentration risks, what happens if a TEFI fails or stops operating, either voluntarily or involuntarily, the appropriate definition of insolvency for TEFIs, and whether the OSBC can examine additional items beyond those currently enumerated in the bill. I have attached to my testimony a table summary of our agreements, and that table contains section numbers, so you can cross-reference that to the bill and find the various provisions. I'm happy to answer any questions, and I appreciate the committee's support of the bill.
Questions for Matt? Well, Matt, a couple questions that I had. I think it's really good that you've, not a question, but a comment, that I think it's good that you've gotten together and come up to look for points of agreement and ones that are acceptable to wait till you see what an exam discloses. Looking at this bill and some of the things that would come out of it that are in it now, and some things that are, I guess, looking for the right wording or looking to work together. and you said soon. What do you think the time frame from your point of view might be to get those so that we could actually bring it back, work the bill, and take out the things that will go after an exam and put in the things that are agreed upon, including the ones that you're working on the final wording on?
I think we're very close. I don't know about an exact time frame. I hope it would be in the next week or so.
Okay, and I mean, it would be probably good the way we set in the session is if it could be in a week and we could come back and actually work the bill. But it looks like you've come up with a lot of the points in here when you look at it that are agreed upon, and some that will be agreed upon as soon as you kind of get the wording in. And I just appreciate the effort that the Office of the State Bank Commissioner and beneficent has made to make this happen.
Thank you.
Turned it off. Representative Burkham.
Thank you, Chairman. Under Section 4 for the application fee, it's listed as $500,000. My understanding was, I think for the first time, that was kind of cover all the costs to get this program rolling. Is that, is that a common number for some type of application? It just seems like a pretty big number to me.
It's definitely higher than our normal application fees. Our primary concern for this bill is switching it to being a non-refundable application fee. There aren't other TEF fees applying right now. We're planning on revisiting the fee amount after the exam. It is going to be a little bit higher than our fees normally because we have to hire, right now we're hiring external attorneys and external accountants to help us evaluate a TEF fee application as we develop the expertise to do that ourselves. But yes, that is higher. We left the amount as the amount set by the legislature in the TEF fee Act, and for now we're switching it to being a non-refundable, an application fee as opposed to a fee after the charter.
Okay, thank you.
Other questions for Matt? Well, Matt, thank you very much for your work on this and for outlining each of the things that you worked on as to where you can clearly tell whether it's agreed, it's being worked on, or it will happen post-exam. So it makes it much easier. Thank you.
Thank you.
That is the only proponent that I've had listed. Is there anyone else that would want to speak as a proponent on House Bill 2489? If not, we'll close the proponent portion of the hearing, open the neutral portion of the hearing, and I show no one listed and no written on neutral. Anyone wish to testify as neutral on 2489? Not, we'll close the neutral portion of the hearing and open up the opponent portion of the hearing on 2489. And I believe that you'll probably hear that this testimony was prepared before some of the things that Matt talked about had been agreed upon. So I would like to welcome to the hearing and back to Kansas, Derek Fletcher, the President and Chief Fiduciary Officer of the Beneficent Company. Welcome, Derek.
Great. Thank you, Chairman Kelly, and thank you, members of the committee. And I know it won't disappoint you to know that my comments this morning will be very brief. So did want to point out an important component of the TEF fee legislation, which you all are certainly aware, and that is one of the fundamental purposes of it was to create collaboration between the industry and the OSBC, and in particular as it relates to the pilot program between Beneficent and the OSBC. And I'm very pleased just to report to you this morning that that collaboration has occurred and is occurring, and in particular with respect to this bill. We've had conversations really as late as this week about the bill, and as Matt correctly stated in his testimony, we've come to an agreement on many of the features and provisions of this legislation, and believing them to be helpful in terms of the clarification they provide or the additional guidance that it provides with respect to examinations of TEFIs. So we originally were opponents to the legislation insofar as there were certain items, as Matt indicated, that we believe are really premature to address and that we should evaluate after an examination, where each of us has the opportunity to really see how that examination goes, look at transactions together, and then ascertain what appropriate substantive changes should be made to the legislation. But we are very pleased, and again, I would agree with Matt in terms of there's certainly some of the language that's incumbent on beneficent to suggest, and I do expect within a week, Chairman Kelly, that we should be able to have that language together and then be able to submit a bill that incorporates all those agreed upon features. So with that, I'll certainly stand for any questions, but appreciate the time this morning.
Any questions for Mr. Fletcher? Representative Osmond?
Thank you, Mr. Chair. I just have one general question. Forgive me, as informational because I'm new to the committee. Can you explain more about beneficent, your relationship to the OSBC and to the TEFI Act?
Yes, sir. So we are a financial services company that has applied and received a charter from the OSBC and the State Banking Board as a technology-enabled fiduciary financial institution, providing services to customers that own what's defined as alternative assets. And so certainly we're involved with this committee last year in terms of the passage of the TEFI Act and are part of a pilot program that enables beneficent to partner with the OSBC, again, to work through transactions, to really prepare kind of the regulatory framework to open Kansas up to the industry at large. And so that has manifested itself not only in just dialogue between our company and the OSBC just in general, but also as it relates to the legislation and what statutory changes should be made in order to improve or refine or clarify that process. So I don't know if that's responsive to your questions, but that's kind of the industry and our role and kind of where we are from a status perspective. Yes, sir.
Any other questions? Well, it doesn't look like it, but Derek, again, I appreciate the effort that Beneficient and the OSBC has to get together and come up with agreements, and I appreciate what looks like will turn out the intent of this legislation to take the things that are agreed upon and sort out the ones that can come better after an examination, so you could look at it with the final purpose really being to put TEFIs in a position to continue going forward in a positive manner and make it where as new applications are received that they can be processed in a uniform manner. All of the TEFIs in operation can be governed in a uniform manner, and that we come out with something that you as an organization, the State Bank Commissioner as their organization, and the legislature feels that is when the exam takes place and the fiduciary financial institutions and get their examination and their charter, that it is a good seal of approval, and that it gives confidence to the legislature, to the individuals that will be your clients, and to you that we've got a good product here in Kansas that can carry us forward. So appreciate all your efforts.
Sir, I agree. Thank you so much.
Now, also have down Alan Dinas. Alan, you have a few comments that you would like to make. He's the Managing Director, Fiduciary Financial Institutions for the Beneficient Company, and he's headquartered here in Kansas. Welcome, Alan.
Thank you. Thank you very much. I really don't have much to say. Derek's done a pretty good job of summarizing it. What I do want to reiterate is that we've worked with the Bank Commissioner's Office in a very collaborative way. they're listening to our concerns and our thoughts, and we're really trying to be cognizant of the things they're trying to do. And I think we're moving it forward about as expeditiously as we can at this point. As early as yesterday, we had a meeting with our asset management folks, and the members of the State Bank Commissioner's Office will be examining those assets to really educate them into what they were going to be looking at, what the thought process should be. We're not telling them what it is going to be. That's their choice, but really getting them acclimated to how we do business in an industry that culturally and from a language standpoint is very different. So we've got 2 more meetings set on assets. We'll keep working on the legislation, and I think things seem to be moving along very well. And I really do commend the Bank Commissioner's Office. They're working very hard. That's my comments. If there's any questions, feel free to ask, please.
Representative Hsu.
Thank you, Mr. Chair. This is more just of a quick comment. I also want to echo what the chair said about what the 2 parties here are doing. It is an extremely difficult task to have a new product, right, that's first of its kind, and to be able to regulate it in an appropriate manner, but also not halt or stop progress while doing so. And then I think I really commend both parties for doing that. It's a tough task, but I think we're moving forward, and that's what we would like to see.
Thank you.
Any other questions, comments from the committee? No, Mr. Dinas, again, appreciate for your efforts. I know that you're on the ground here in Kansas, so that you're doing a lot of the coordinating of it. And I think we'll end up, like I mentioned earlier, I think we'll end up with something when we come back with the bill that kind of outlines what we think can be agreed upon and is necessary to be agreed upon now, and it will set out kind of the process for what we'll do after the exam to put the final touches on it so that we'll be ready to open it up to others. And so your efforts are appreciated to both the State Bank Commissioner's Office and Beneficient for these efforts.
Thank you very much.
Well, this is the only kind of opponent, non-opponent, as it turned out, thankfully. Written oral testimony, I show nothing written, and so anyone else want to speak as an opponent to 2489? If not, that takes care of the testimony for House Bill 2489. We'll close the hearing on 2489, and that's the only thing that we really have today. Hopefully, like I said, next week when we have our meeting, one of the things that we'll hope to take up next week is the bill that changes the date to December 31st, which is should be a very easy bill because it's only one change that came out of the Joint Committee. And then we hope we'll be able to take this one up too and have both of these going and moving to the floor and get agreement and have something that we can get through fairly quickly to get to the governor for her signature, I'm sure, on this one. So next week we'll meet, our next meeting will be Monday, hopefully after another Chiefs victory that will send things to a great couple weeks there in the future. But we will meet at 9 o'clock Monday morning. For now, we're adjourned. Thanks for being here today.